Attorney Dennis Kirk. Are you Stevie Don Coulter?
Yes.
Pardon me?
Yes, sir.
Right away, something feels off. The judge is asking basic questions, and the defendant says she has a bad headache. Now, in court, physical complaints can matter, but they don't pause proceedings unless there's a real medical emergency. Is this stress, withdrawal, or something deeper? Let me know what you're thinking already.
All right. Are you all right, Ms. Coulter? I can't hear you. You have a really bad headache? Anything else wrong with you? All right. Well, we'll go ahead and have this pretrial, but a couple of things I want to talk about after that. This was actually set for a hearing, I believe.
And here's where the tone shifts. Positive tests for multiple substances, missed probation appointments, no contact with treatment services. That's a major red flag. When someone is asking for treatment in lieu of conviction, compliance is everything. If you don't follow the rules before sentencing, why would a judge trust you after?
For the defendant to enter in a plea for treatment in lieu of conviction, or at least have the hearing on that. I have a report from the probation department that she's been testing positive for gabapentin, marijuana, methamphetamine, and amphetamine. Hasn't reported since the 21st of September. Called on the 29th, said she didn't have a ride, wanted to be rescheduled, does not contact since then. Referred to Talbot House for an assessment. There's been no contact there they've had from Talbot.
But I just have a question. Does it even test for gabapentin on a 10-panel drug test?
What's that now?
Does it test for a gabapentin on a 10-panel drug test?
Okay.
That's what
Ms. Talbot, or Miss...
Because someone said that to me in the PO's office, and I'm a very intelligent person, and I know a lot, and I just look stuff up all the time. And I mean, I can't, it's hard for me to plea in lieu of, honestly, because of the things that I found in this. That's like kind of like, I don't know.
Boom. The judge cuts through it. Immediate drug test. That's judicial discretion in action. When the court suspects ongoing substance use, they don't debate it, they verify it. Notice how the conversation spirals? This is where courtroom control starts slipping.
Ms. Coulter, I'm going to have you drug tested here. Probation officers here. I'm going to have them drug test you. See.
I've never been in trouble. No, I just got beat the shit out of by a dude who left a bite mark on my arm, and my head hurts now because of it. Like, I mean, he beat me up until I was literally talking retarded. And in this statement from the police, from this one, it says, then I identified female Stevie Coulter, not Stevie Coulter identified herself after her social security number. So he arrested me based off of...
Okay, well, that's not what we're here about here today, Ms. Coulter. It's clear that you're not in a situation...
But they lied also, though, Judge. They
don't interrupt me, Ms. Coulter.
Hair and everything. I was denied access to the videos.
Ms. Coulter, be quiet.
Wrong.
Be quiet. Don't speak.
Because they lied.
Be quiet, I said.
They lied.
I'm not lying. I said be quiet. You understand me?
They lied.
And there it is, contempt of court. Let me explain. Contempt isn't about the original charge. It's about disrupting court authority. Interrupting, refusing instructions, arguing out of turn. Judges can jail you instantly for that. 10 days, just like that. Question for you. Was a judge too harsh or completely justified?
All right, I'm holding you in contempt, and you're going to be sentenced to jail for 10 days. Now, if you open up your mouth again, and you need to stay on topic here. All right? You're going to go to jail for 10 days right now. I'm going to have you tested by the probation department,
Okay, so
and then we'll decide what's going to
I already failed a
happen.
drug test. They already did a mental health assessment when I got out on the terms of the first time I went out. Or I got out when I first
Miss
originally got out.
Coulter, you're disrupting this
I promise
proceeding.
you, I'm not trying to be like that.
Yeah,
But it's in
yes,
black and white. It's right there.
all right.
I highlighted it. Then I identified within the first 3 lines.
I don't even know what you're talking about because it has nothing to do with what we're here for
The police
today.
officer that arrested me, it was wrongful arrest, and then I had 5 cops on me.
All right, you have an
I
attorney.
had 5 cops on me.
Miss Coulter, you have an attorney.
I wasn't even I didn't even touch that girl. It was my only form of
Take her into
defense.
custody, put a cuff on her.
It was my only form of defense.
You're going to jail, and we're going to have you
It was
tested.
my only form.
I want you to-
test me. You already did. So what?
Has she been drug tested today?
I'm not on fucking drugs today. I have a headache
That's
because
enough,
of a
Miss
serial
Coulter.
killer. That's fucking, I don't even know where he's at.
Way back.
Now, this is a critical turning point. The attorney requests a mental health evaluation. Legally, this matters because if someone is incompetent to proceed, the case pauses. The court must ensure the defendant understands the process and can assist in their defense. But here's the bigger question. Is this a mental health crisis, substance-induced behavior, or pure courtroom meltdown?
I gotta give him a shit.
Mr. Kirk, I think you need to file a request to have this defendant evaluated for mental health. I think
I need resume so they don't get fucked with.
you want to help her.
I don't need to be in jail. No, I'm not fucking crazy. Not gonna fucking, I swear to God. I'm not on fucking drugs like that. It's wrong. You're expecting these cops to be out here fucking doing this shit to people? When it's a conflict of interest, I want a new trial. It is. Fucking, I swear to fucking God. I hate every fucking person in this fucking courtroom. That ain't a fucking joint. That ain't a fucking joint. Just because I pointed it out black and white.
All right. No, go ahead. Mr. Kirk, if you would, I was trying to say this, I don't know if you heard me or not. I'm sure you have mentioned it already. Obviously, she needs a mental health evaluation.
Based on this and then also some other information that was presented
Yeah.
by
Yeah. Are they on their way? Well, next time he leaves like that, let me know, because I did not know. I knew I was going to have her taken in custody. I didn't know he wasn't here. All right.
Final decision. 10 days for contempt, plus a mental health evaluation request. What started as a potential treatment opportunity just escalated into jail time and psychiatric review. This is a powerful reminder. How you behave in court can drastically change your outcome. So I want to hear from you. Was this preventable, or was the situation always headed here?
So, 10 days contempt,
I don't leave my house because of this thing.
and then file your evaluation.